Yes, sir.
Perfect. Your Honor, people in the courtroom, we've heard through testimonials and seen through evidence the facts provided for this case we are all present for today. After confirmation from Willow Holloway that these text messages were raw, undoctored messages, we have presented with the text messages that indicates the initiation of communication from Sherif Kareem to Miss Holloway. Throughout these messages, we can see that both parties wish to have a cease of communication. However, Mr. Kareem remained persistent. He continued to send what we can understand from Miss Holloway to be unwanted messages. As stated in our penal code, repeated messaging. This was not one singular message, this was multiple over a continued time span. We have even heard from officers that Mr. Kareem was informed not to continue messaging Willow Holloway on her behalf. Whilst in the interrogation room, Miss Holloway received another text message from the recorded phone number. All at the same time that Mr. Kareem had his phone and was even found with it in his hand without authorization throughout his interrogation. As we have been informed, the message received after his lineup, after Miss Holloway's presence for the lineup, and Mr. Kareem's interrogation all occurred around the same time this final message was sent. A final message, despite being informed to cease communication from not only Willow Holloway, but from two members of law enforcement alongside it. Again, repeating their communication of unwanted messages. Thank you.
Mr. Kareem.
Okay, so today we have proof of my innocence, and I hope, actually, and proof that DOJ withheld evidence today. The text messages between Willow and the number, both parties told each other to stop texting each other, and even Miss Holloway even stated that they're not going to stop. You could see on line 17 in that she continued to say she was not going to stop. There's also no proof that I was the one that texted. Seth even stated he could not prove the text message from Willow was altered or not, or nor can the court prove its authenticity. Sorry, English is not my first language. Okay. Willow stated in testimony that it was possible that someone who could have sent a message and testified that someone did text her saying they have told her it was from them. And also told PD and DJ, but you can see, Your Honor, there is no evidence provided in dockets of the text messages Willow receiving from someone else related to this case. Also, Seth Kennedy also stated that he grabbed me, tried to make me speak, and then grabbed me and put me against the window against my will to speak up. But also stated he could not prove that the last text message in the interrogation room was even from that day. We have no proof that it was maybe prior from a different day or any other day that the screenshot could have been taken. As Mr. May stated, he said in his own testimony, he said I texted Charlie Kingsman. You can also see in the interrogation, Mace had me against my will when I told him multiple times I want to go home and I did not want to answer any questions, and continued to antagonize me, even though I said I don't want to answer. This is a definition of harassment, if I understand it correctly. Everyone in the state of San Andreas has a right to answer any question and stop questioning at any given time, as it's their right. Forcing someone to sit through an interrogation is a violation of my rights living in the state. Finally, the note was placed outside. There is no proof of who can have put that note out there. That is all.
All right. I've heard both of the closing statements. This court will go into recess for an undetermined amount of time for me to deliberate. Won't be very long. So I'll see y'all then. And like I said, this court's in recess. Ms. Holloway, while you're still here, I'm going to have you come back up to the witness box. I'm going to explain something to you that is pretty new here in the state. That's going to be the case of 2024 CM011, where the court laid out the requirements to verify phone records. There are several means to do that. That'd be through a search warrant, through a court order, through verbal testimony by both parties, or through physical authentication. And I would seek from you to physically authenticate the text on your phone. Would you mind pulling out your phone and showing me the text messages? Okay, this satisfies me. You may step down and go back to your little area. All right, the court's going to issue the verdict. The defendant will stay standing. I'm going to kind of summarize my feelings about this case, and then I'll issue the verdict as I normally do. So a lot of issues were brought up during testimony. One of the biggest qualms I had was about one of the officers' testimony about the defendant's Fifth Amendment right, that he does not have the opportunity to cease questioning. I'm very troubled by that, and I don't agree with it. The defendant has a Fifth Amendment right not to incriminate himself, and if he wishes to cease questioning, he may. But this case primarily revolves around some communications that have been exchanged dating back to November, where the defendant and one of the victims, Ms. Holloway, had both told each other to cease questioning, yet they both continued to do so. And that fact is undisputed, I think. That's been submitted as evidence. The court has reviewed the evidence, and multiple requests by Ms. Holloway were made to cease questioning. During the interview, and I call it an interview, it's not an interrogation, it's an interview. During the interview, one of the officers stated to Mr. Kareem, as he testified, to cease communications with Ms. Holloway. This is in addition to Ms. Holloway's requests back in November, and there's another date as well where she requested that the defendant cease communications, and he failed to do so. And on the day that the defendant was subject to an interview, when he was told to cease communications, he didn't. I don't believe for a minute that the defendant pulled out his phone, texted Charlie Kingston or Kingsman, or whoever he pontificates he texted, and then quickly put his phone back in his pocket. As Holloway testified, and I believe Officer Kennedy testified, that as Holloway had made it clear to the officers that she had received a text message coming from the same number that was engaging in harassing communications. So with that in mind, the court adjudicates the defendant guilty of harassment and will sentence him to 30 months imprisonment and issue him a fine in the amount of $1,000.